with the rest of the, a few members of the firm every J term from Harvard teach for 3 weeks, like a Supreme Court litigation clinic for 10 students.
Where did you say you do that?
It's Harvard, but they come to us. So they spend January in our offices doing actual Supreme Court litigation. And we teach it for 3 weeks. I've done it basically every year since after I was barred. I had my Supreme Court bar for 2 terms, and then I've taught it all 4 years after that. It's a lot of fun, and it's pretty totalizing actually, because you have like stuff every day, and there's a lot of like, in addition to some lectures and stuff, you're supervising 3 kids who are writing a real cert petition, and then or bio, and then you've also got like, we go and meet Justice Kagan one day. We meet with the SG usually, but then we meet with like a bunch of other people who do Supreme Court litigation around town. And so it's a great class and experience for the students, but it like takes up a lot of January every year. It seems, I think, oh, this is manageable, like, it's just a few hours. It's like, no, it's basically like all day, every day.
All month.
Yeah, exactly.
Sounds like fun.
Where are you? Cornell?
Cornell, yeah.
Yeah. Which is in Ithaca, right? The law school?
It is, yeah. Yeah. Although I live in New York City and I commute back and forth.
Where are you now?
Right now I'm in South Carolina. A few weeks ago, when it became clear that we were all going to be occupied remotely rather than in person, we just like drew a line on a map, like how far south can we get in 1 day's drive without stopping?
Yeah. I like it.
So we came in here. It's been great.
Okay, it says ready to go live whenever we are. I wonder what that means.
I think you could kick it off, right? If you want to.
Okay.
All right.
Well, welcome everybody, and Nelson. I'm Eric Citron. I am a contributor to SCOTUS blog and also a Supreme Court litigator in Washington, D.C. with Goldstein and Russell. I'll let Nelson introduce himself in a second. And we're here to talk about Little Sisters of the Poor against Pennsylvania, which the Supreme Court will be hearing on Monday by telephone. Nelson, you want to say hello, everyone?
Hi, I'm Nelson Tebbe. I'm happy to be here to talk about this case. I teach at Cornell Law School, where I run courses on constitutional law, freedom of speech, and freedom of religion. And I write about all 3 of those topics, both kind of academically and also sometimes in the popular press. And
you have a brief in this case, right?
Yeah, together with some other like-minded scholars, we filed an amicus brief in this case. It was authored by Joshua Matz.
And who are you supporting?
We filed on the side of the states.
Okay, so I'll just say a few words about the case to get everybody situated, and then we'd like to have a kind of more free-ranging discussion about what the case is about, the broader topics at issue, and ideally we'd love to be answering questions that you may have about the case. And so if you have any, please use the Q&A function to lob your questions at us, and then we'll see them and we can address them live on the webinar. It'll be a lot more fun for everybody if it's interactive in that way. So anyway, this case is either the second or third iteration of dispute among nonprofit institutions and the government about the contraception mandate in Obamacare. So just to give a little bit of history, Obamacare has a provision that requires employers to provide coverage for their employees that covers preventative care. And during the Obama administration, that was interpreted to include female contraception. And in the first iteration of this issue, some privately held, closely held corporations, including Hobby Lobby, challenged that rule insofar as it required them to provide female contraception, notwithstanding their religious belief that that contraception, or notwithstanding their view that that contraception was contrary to their religious belief. And the Supreme Court held that under the Religious Freedom Restoration Act, which imposes a very high standard for federal government laws that burden religion, that some kind of accommodation did have to be provided for closely held private corporations. And then a similar litigation came up regarding nonprofit institutions like Little Sisters for the Poor. Little Sisters then had a litigation about exactly how they had to go about certifying that they had a religious exemption, insofar as that certification was going to end up allowing their employees to obtain the same coverage directly from the government. They didn't want to be participating in it at all. Their view was participating in any way violated their religious freedom. And the court heard a case about that and sort of decided that the parties seemed close to working it out, and more or less directed them to work it out. That was at the end of the Obama administration. Then what happened is, when the Trump administration came in, they decided to provide a much broader exemption from the mandate altogether for institutions like Little Sisters of the Poor, that is, nonprofit institutions that say that they have a religious objection to providing coverage. They don't have to provide coverage, and the government isn't going to step in and provide it either. And the question is, now, does providing that kind of accommodation, much broader than the Obama administration was willing to provide, itself unlawful? And there might be one or two reasons why. It could be unlawful because it exceeds any authority that the government has under the Obamacare statute and the Religious Freedom Restoration Act, or it could be unlawful because it goes so far in catering to the religion of the employers that it actually violates the free exercise of religion on behalf of the employees and other interested parties, or it could be an establishment clause violation. So bending to religion that it violates what we think of as the separation between church and state. Those are the questions in the case. There's also a question about whether or not the Little Sisters can appeal this case because they've won a case and have a injunction in their favor in that they've won in another case. But we're going to leave that aside, and we're going to focus on the more interesting issues in the case. Nelson, do you have anything you want to add to that summary?
No, I think that's right. It's a complex kind of litigation with a long history that nevertheless raises, some foundational questions of religious freedom, administrative law, standing law.
Why don't you start by, can you tell us a little bit about what you argued in your brief, what the focus of your discussion was, and what you see as the sort of ripest and most interesting issues in the case?
Yeah. So together with some other scholars, we got involved in this set of cases early on when the Hobby Lobby litigation was still in lower courts. And there the government was arguing for the contraception mandate on the basis of, a compelling interest that the government had in protecting women's health and women's equal employment opportunity. And we thought there was something missing from that argument. And what was missing was the perspective of the employees, that women would lose access to cost-free contraception if the religious businesses that were at issue in that case won the litigation. So we started to float an argument in lower courts about third parties, namely employees. And there's a line of cases in the Supreme Court that holds that the government can't voluntarily accommodate religious actors if lifting a burden on one private citizen will impose a burden on some other private citizen, third parties, because that infringes on the religious freedom interests of these third parties, these other private citizens. They can then legitimately say, I'm being harmed as a consequence of the religious beliefs of some other private citizen, and that violates the Establishment Clause according to the Supreme Court. This line of cases. So we started to run this argument in the Hobby Lobby litigation that exempting Hobby Lobby would violate the Establishment Clause because it would impose harms on third parties. And in that case, there were tens of thousands of employees at issue, 13,000 for Hobby Lobby itself, but there were a lot of other companies involved as well. And by the time the case got to the Supreme Court and the Solicitor General argued it, the third party harm issue was central to the case. And we felt like we had a role to play in making it that way. And subsequently, as the issues have moved on and the disputes have concerned nonprofit employers, as this case does, some of the same concerns have arisen because the nature of the complaint by employers is much the same, that they don't want to be complicit in the provision of contraception coverage for their employees. So the only thing that will satisfy them and mollify their religious qualms is if they are exempted altogether and their employees don't receive cost-free contraception coverage from the same insurance company. So the third-party harm issues have remained kind of salient, and in this case, they're especially central because the Trump administration doesn't make any attempt to provide for employees who lose contraception coverage because they're accommodated by the government. Instead, the Trump regulations at issue in this case leave employees completely without contraception coverage. There's no alternative coverage provided for them. So the worry about third-party harms is very serious here.
So just to clarify, what changed from the employees' perspective as between the Obama administration and the Trump administration? After these cases were originally brought in the Obama administration, an accommodation was worked out or being worked out where the employers were not going to provide the coverage directly, but employees were still going to get coverage for this kind of contraception. And there was a dispute remaining about exactly what the employer was going to have to do administratively to trigger the government to do the covering instead of their own covering it themselves. But the employees were going to get coverage at the end of the day. Is that right? And now they won't get coverage at all.
Yeah, exactly. Actually, the exemption for religious nonprofits had existed from the beginning. And it was crafted by the Obama administration. And basically it said, if you want an exemption, a nonprofit religious employer, all you have to do is notify either the government or your own insurer or a third-party administrator that you have that objection. And that's it. You just notify the government. And that allows the government or the third-party administrator or insurer to know whether you're going to stop providing that coverage to your employees, so that and then the government can step in and provide that coverage itself. And the way that works depends on technical things like whether you're self-insured or whether you have an insurer or whatever. But either way, what happens is then alternative coverage is provided to employees. And Little Sisters argued that's not good enough, because even though we're exempted from the contraception mandate, the notice that we give either to the government or to our insurer or third-party administrator triggers the coverage of our employees by someone else. And that's too much causality, right? We're too connected to the eventual provision of contraception coverage to our employees. That makes us complicit and violates our religious beliefs. So the Trump accommodation deals with that argument by just not providing alternative coverage for employees. The employees just lose coverage.
Now, what is the source of authority and there could be two problems with that. As you mentioned, one of them could be that the employees' own rights are being violated to their own religious freedom. or to their right to be free from a government that is too in bed with religion or something like that. But there could also just be a sort of lack of authority for the government to take this step, given that the Obamacare was interpreted at least to include coverage in ordinary circumstances for contraception. So what is the claimed authority for the Trump administration to impose this kind of accommodation that ends up depriving these employees of coverage?
Yeah, I mean, whenever an agency issues a regulation, it has to, identify some source of authority to take that action, usually the statute itself that it's implementing. Here, there's no provision in the ACA itself that sort of clearly allows for religious exemptions like this. So instead, in addition, I should say, the Trump administration has pointed to the Religious Freedom Restoration Act as a source of authority for this religious exemption. And in order to make that argument, the other side says, well, there's no violation of the Religious Freedom Restoration Act because the Little Sisters are already exempted. They are currently exempted under existing regulations. They have an exemption. They don't need one, right? They don't need to invoke the Religious Freedom Restoration Act. And the government says, no, they do, because the existing exemption actually burdens their religious beliefs. They believe that the existing exemption makes them complicit in the eventual provision of contraception coverage to their employees.
So that argument in this case ends up relitigating the same issue from the previous case in a different posture in a way. Is that right?
That's what the states say. They say you're just arguing that the existing accommodation violates your religious beliefs. We've done that litigation already in the cases leading up to Zubik, and there, the overwhelming majority of circuits said you're wrong. There's no substantial burden on your religious qualms or beliefs here because the provision of contraception coverage that eventually extends to employees is provided by the government. There's no causal connection between your claiming a religious exemption and the provision of contraception coverage to employees. There's no substantial burden on your religious beliefs, even if we accept your religious beliefs as sincere and reasonable. It's the government that provides alternative coverage, not you.
That actually intersects with one of the questions that we've just received. So, and I'd like to encourage everybody who's on, again, to go ahead and lob your questions at us. The question posed was, you said even assuming that this really does violate their religious beliefs, does a court generally have to accept the proposition that a party's religious beliefs are impacted or infringed by a given government law, or is the court entitled to look behind that kind of argument? Because I think for some people, it's hard to accept even the premise that it really does impact somebody's religious practices or beliefs to, file a document that says that they have a religious belief that prevents them from providing coverage or something for their employees.
Right. So the court, under existing law articulated in Hobby Lobby and other cases like Thomas Review Board, is very deferential to religious believers as to whether they really have a religious conviction and whether the religious conviction is reasonable. The courts won't ask, whether this is a reasonable belief. They will intervene. Courts will intervene at 2 points. They'll ask whether the belief is sincerely held, right? Like whether the person is subjectively sincere in saying that they have this belief. And then courts will also will also kind of make a decision about whether the belief, though reasonable, is substantially burdened. So it is the court's job to decide whether the belief is substantially burdened, but the court has to defer to the claimant on whether the belief, exists. It's really religious in nature. It really binds them, and so forth.
But the sincerity issue, it's nominally open, but very few cases are courts willing to look behind the sincerity of the religious belief in practice, right?
No, that's true. I mean, the main places or types of cases in which sincerity is questioned is where an articulated religious belief, kind of dovetails very closely with a secular interest. So, um, a classic example is smoking marijuana. Rastafarians have argued, that they deserve a religious exemption from drug laws in order to participate in, sacred rituals. But lots of people have a secular interest in, the recreational use of marijuana. So courts have sometimes used that kind of confluence as a reason to question sincerity. Courts also, though, will use sort of tried and true techniques like demeanor evidence to adjudicate whether someone is sincere in their religious beliefs. And courts feel quite comfortable doing that, right? They do it in lots of contexts. Likewise, it has to be up to a court to adjudicate whether a burden is substantial, right? And that's what courts did in these lower court cases. They asked, look, we just don't believe that your belief, your opposition to contraception coverage is really interfered with here. You're exempted, and your employees receive alternate coverage by operation of federal law, not because of anything you do.
Yeah, and another interesting wrinkle is that this issue often comes up in the context of the Religious Land Use and Institutionalized Persons Act, which is a statute in which the federal government said that it was going to apply the strictest scrutiny to laws that burden religion, including in connection with prisons. And so you get a lot of prisoners arguing that they must get some kind of accommodation from ordinary prison rules and regulations on account of some religious belief, which I think courts are more willing to look behind the sincerity of those, the alleged religious exemption from having, to eat what the rest of the prisoners are eating or the like.
Yes. The most entertaining example of this came from a reporter who called me once from Nashville. Apparently there was a sex club in Nashville that was operating downtown, but the area in which it was operating became very fancy. And so they had an incentive to sell their property, and they did sell it. They bought an alternative site in the suburbs around Nashville, but it was right next to a church and also, I think, a church-run school. So there was a challenge as to whether they had land use authorization to run this sex club in the suburbs. And they responded to the challenge by arguing that they were a church and that they had religious reasons for running this club. And court didn't take long to find that there was a sincerity problem there.
Yes, and sometimes doubts about sincerity end up being resolved on other grounds. The courts really don't like to have a doctrine of looking behind what people claim to believe.
That's right. Yeah.
Even though that may be what they're doing at the end of the day.
Right.
Now, I think there's going to be a lot of sympathy for people's view that this isn't that big a burden on the Little Sisters, and is a pretty big burden on their employees because, the Little Sisters were just asked to make a certification, and the employees are going to be deprived of an actual government entitlement. But there's another overlay here, which is the sort of wide-ranging discretion that's available to the executive branch in terms of how it implements a law like Obamacare. How do you see those interacting in this case? Do you think that that the government is just going to be able to rely on sort of the breadth of the way that it can interpret what preventative care requires, or is this going to come down to like a balancing of one party's interests against another?
I'm not an administrative law expert, so I'll leave sort of that side of it to other people. But insofar as the government is claiming the Religious Freedom Restoration Act as statutory authority to promulgate this exemption, I think there are a couple of issues. One issue is that, the one we were just discussing, which is that the Little Sisters are already exempted under current regulations. And it's doubtful whether that exemption does impose a substantial burden on them. And even if it does, whether the government can argue that it has a compelling interest in preserving women's health, and that the accommodation they're already offering is the most narrowly tailored means of pursuing that interest. So that's one issue. Another issue that's raised by Marty Lederman in his amicus brief is that actually the Trump administration's accommodation applies to anyone, any nonprofit employer that has a religious objection to the contraception mandate, not just to the existing accommodation. So it would sweep in lots of people who are not substantially, lots of employers who are not substantially burdened under any sort of interpretation of RFRA. So that's a issue. And a final issue is that the Religious Freedom Restoration Act is designed to be judicially administered. It's a case-by-case kind of standard that judges will use to evaluate individuals' claims that they've been burdened by a neutral government action. So it's kind of poorly tailored to or designed to deal with this situation where the government invokes it as authority to make sweeping changes to regulatory law.
So we have another question from the audience, which is, what should we expect in oral argument based on similar cases in the past? How will the dynamic change with Kavanaugh and Gorsuch on the court? Well, I think one thing that's worth noting is that Justice Gorsuch has been a particularly strong supporter of the religious objectors or the religious parties in cases like this one. He often tries to channel Justice Scalia, but Justice Scalia was actually something of a skeptic of making exemptions from ordinary laws for religious objectors. And that is not a position that Justice Gorsuch shares. I think his view is we really ought to be accommodating religious objectors to the extent possible. And that's particularly true when you have when you're not talking about just the constitutional free exercise clause, but RFRA, the Religious Freedom Restoration Act. And so I would expect Gorsuch to push the court even more in the direction of the Little Sisters than Justice Scalia did. I think that's probably true of Kavanaugh vis-a-vis Kennedy. I don't think Kavanaugh is quite as, I wouldn't place him in the same spot on this spectrum as Gorsuch. But, Kennedy is the one who believed that some accommodation between the Little Sisters position and the Obama administration's position could be worked out the last time around. And I would expect Kavanaugh, I don't think he's going to be to what you might consider the left of that position or to the employees side of that area. He may be in a similar place as Kennedy. He may be even more sort of aggressively favorable towards the religious position in a case like this one. What do you think, Nelson? Similar?
I think that's right. I mean, remember that Justice Kennedy wrote separately in Hobby Lobby and took some positions there that that harmonized with the dissent rather than the majority in that case. And some of those positions are consequential in this litigation. One of them is that, Justice Kennedy said outright that the government has a compelling interest in protecting women's health and their equal employment opportunity by providing cost-free contraception coverage. And so that meant there were 5 votes for that proposition in the first round of litigation on the contraception mandate. And now with Justice Kavanaugh replacing Justice Kennedy, that might change, and that could be consequential because one of the issues here is whether the government has a compelling interest in imposing the contraception mandate on employers, or at least providing alternate coverage for employees. So that could be important. And the other question in which Justice Kennedy kind of diverged from the rest of the majority in Hobby Lobby was on third-party harms. I mean, he said quite clearly that the existence of third-party harms is a problem, and maybe even a problem of constitutional magnitude. It didn't come up in Hobby Lobby itself because the premise of the majority opinion was that that these employees could be accommodated by the Obama administration, which could extend the nonprofit accommodation to include at least companies like Hobby Lobby that were closely held. But it does come up here in a very direct way. And so whether Justice Kavanaugh differs from Justice Kennedy on that issue, which I imagine he will, that's my prediction, might really be consequential here.
Okay, we've got another question from the audience. How do you think the court will treat the argument by the states that HHS did not have the authority to issue exemptions under the ACA at all, in light of the fact that the Obama administration also promulgated exemption regulations to the contraception mandate? Do you have a view on that?
Well, I'm not an administrative law expert, but I'll tell you what the state of the arguments are in the briefs. The states say that the administration lacks the authority under the ACA to issue this kind of accommodation. And when confronted with the fact that houses of worship were accommodated originally by the Obama administration, and they were accommodated in such a way that no alternate coverage was provided for their employees. The states say, houses of worship have special constitutional protection. There's a kind of autonomy that they enjoy that's constitutionally required. And so the Obama administration had constitutional authority to exempt them the first time around. That makes me uncomfortable because I think that those claims of church autonomy are too broadly articulated often, and including in the state's briefs. The cases they cite for that proposition are narrow cases about church property disputes or disputes about the hiring and firing of clergy, and they don't extend, I think, this broadly. So that makes me a little uncomfortable. My preferred mechanism for dealing with this issue would be the Establishment Clause. I mean, I think that rather than asking whether the administration has statutory authority, I think rather it's more profitable to ask whether third parties would be harmed. And in the case of houses of worship, I think the harm to third parties would be minimal. And the Obama administration said this at some point anyway, because they can presume that employees of houses of worship, like actual churches, mosques, and synagogues, will share the religious beliefs of their employers. So if they lose contraception coverage because their employers are opposed to it on religious grounds, then the employees probably will be opposed to the use of contraception on religious grounds too, and the harm to third parties will be minimal. That seems like a better way of rationalizing the existing accommodation and the difference between the accommodation for houses of worship on the one hand, and this proposed one by the Trump administration, where the harm would be very serious, irreparable, and wide sweeping.
Yeah, I get the sense that the court is going to be unwilling to say that the Trump administration lacks authority to issue regulations because the Obama administration has already issued them. I think that seems like the kind of historically contingent fact that the court doesn't usually like to rely on. If the statute permits regulations to be issued, then it should also permit them to be rethought. The thing is that the statute imposes like a tailoring issue, and so the existence of that is, it requires that the government's regulations be narrowly tailored to address the legitimate government interest and not broader than necessary, or not impinge on religion more than necessary to accomplish it. And when the question is one of tailoring, the existence of current regulations that might be better tailored to accommodate the religious interests on both sides does impact the question of how well tailored the new regulations are. So I hope that answers that question. Let's see if we have any more. No, Nelson, I think we're coming close to the end of our time. Do you have anything else that's on your mind about this case?
I just want to raise a kind of interesting wrinkle in this litigation, which is that, there's a question about whether the government has a compelling interest to impose the contraception mandate with certain kinds of narrowly crafted exemptions on employers. And the government is invoking the Religious Freedom Restoration Act as authority for this new exemption, right? But in order to invoke the Religious Freedom Restoration Act as authority for this new exemption, it has to kind of disclaim that it itself has a compelling interest in enforcing the contraception mandate through the existing regulations. And that's a kind of weird place for the government to be, right? The entity responsible for arguing that it has a compelling interest in protecting women's health is disclaiming that interest in some way. And there's a kind of like, I don't know, conflict of interest or something that's constraining the government in this litigation. And I guess where I would go with that is just to point out that one of the benefits of a freestanding establishment clause protection for third parties here is that it doesn't depend on the government to defend it, right? So the establishment clause prohibits the government from voluntarily accommodating religious actors when that imposes substantial cost on other private citizens is a protection that exists regardless of what position the administration is taking at this moment on the compelling interest question. That seems to me a virtue of the kind of approach that we're suggesting in this case.
Yeah, it strikes me that one of the things that complicates this case is just a question of the lens with which you look at the regulation at issue and its breadth. When you're talking about the regulation as though it just makes an accommodation, you see the Trump administration it seems to be disclaiming an interest in protecting women's health. But if you zoom out and you think about the whole regulatory scheme, of course, it is one that remains protective in the main of religion, of women's reproductive health. Outside of these religious objectors, if you work for Blue Cross or you work for Goldstein and Russell or Cornell Law School, you're going to get the coverage. And so it's not like they've disclaimed it altogether.
In fact, they lack the authority to do that, right? I mean, the mechanism for deciding whether women's contraception should be covered in this provision is given to HRSA, and HRSA looked to an independent body to answer that question. And the Trump administration has not gone through that procedure to declare that there's not a compelling interest in women's health here. So they can't even do that. And that makes it especially awkward for them to be making this kind of argument.
Right, and the statute itself doesn't really cover this issue of how to make accommodation. You're trying to reconcile two statutory schemes at once, and that just creates some disharmony for administrative law purposes. Not to mention the Establishment Clause and free exercise issues that are, I think, a recognized disharmony, right, between trying to grant exemptions and accommodate free exercise on the one hand, and not entangle the state too closely with religion on the other. It's a little trite to say that those are intentions. That's been recognized for a long time.
I think that's right. I mean, what makes the most sense probably is to just forget about the Religious Freedom Restoration Act, kind of accept that the ACA does allow certain kinds of reasonable accommodations to be made as a matter of regulatory discretion, and then impose a meaningful limitation when third parties are harmed.
That does sound awfully reasonable.
Thank you.
All right, I think that brings us to the end. This was a lot of fun.
Our organizers are just asking us to mention that live audio of the argument itself will be available on SCOTUS blog at 10 a.m. on Wednesday, May 6th. So I guess not Monday, but Wednesday. And that you and I will meet again a week from today at this same time to debrief. And attendees can join that as well.
But at that point, I think we'll have a better idea of what will happen. I have to admit, I think this one is a little bit harder to call, because I think precisely because the third party interests are more clearly implicated now than they were in the past. In the previous iterations, the court was able to say, we foresee lots of ways of accommodating the employees so that they get exactly the same thing. And now it looks like they aren't going to get the same thing.
Right.
We see how tolerant the court is of that outcome.
Absolutely. Great. I look forward to meeting again in a week.
Okay. Me too.
All right.
Thanks so much.
All right.